It wouldn't be hard to get an unfair dismissal and then look back at an incident that you thought of and you spoke to a manager about it and you told them that you didn't want to work with that person, for example, or whatever the incident is. Is verbal or articulating it in verbal enough?
It can be. You got to prove it. So everybody, you know, people say a handshake deal isn't worth anything, but that's not true. We, as a lawyer, we love handshake deals because it's very, very expensive to actually prove a handshake deal. But if you can prove it, it's just as good as any other written agreement.
Yeah.
The problem with a agreement that's not in writing or a complaint that's not in writing is you got to prove that it actually happened.
Yeah.
And then you've got to take affidavits, witness statements. They get cross-examined on the stand, and you don't know where you're going to be before walking into the hearing because it's all going to come down to the testimony of the witnesses. And one of the witnesses could be found to be a total liar, or their timeline is completely incorrect and they get caught out as being dishonest. And so when it's not in writing, it's going to be a lot harder for the employee to actually prove it.
So when you said adverse action, there's no limit on the liability, does that mean that, like, what sort of claims are people going, like, if you're unfair dismissal and you think it's through adverse action, you know, can you get $1 million, or, you know, like, how does it work?
No. Generally speaking, the laws around employment is to put the employee back in the same position that they would have been but for the event. So it's not about punishing the employer. It's normally just about putting them back in the same position. So